Sorry about that. I actually had a preliminary matter that I wanted to bring to the board's attention, if it would like to hear it, regarding numbers 3 and 4 on the list today.
How about we do this? I will start. Nancy will proceed. We can read in case number 1, which has been continued. Then we can do 3 and 4, because it sounds to me like you have information to provide. And then we'll go from there.
Perfect.
Okay?
Thank you.
All right. Nancy, you good with that?
That's fine.
All right. Oh, well, we already started recording. Good afternoon, everyone. My name is Melissa Andre. I am the Executive Director of the Tax Review Board. Today is Thursday, June 15th of 2023, and we are convening a session of the Tax Review Board. Please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy, and by continuing to be in the meeting, you are consenting to being recorded. With me today is Board Chair Nancy Kammerdienner, as well as board members George Matthews, Paula Weiss, and Dominique Ward. Nancy, please take it away. I'm going to put case number 2 in the room.
Okay, fine. Thank you. I'm going to give you a notation or an update on case number 1. That's for Dmitry Aristov, last 4 digits of the docket 9251. And that item has already been continued and will be scheduled on another date. I guess our next thing will be an indication from the law department on items 3 and 4 for DR Builders 35 LLC, last 4 digits of the docket 9781 and 9780. But I think we do need to wait until case number 2 comes in, or are you already putting them in? We can't hear you. The mic isn't on.
Can't hear you.
No sound. Good thing we were checking this out. Paula, you don't have your mic on.
Sorry, I think we could probably go on to 3 and 4 while Melissa figures this out, because that's for case number 2. And I think Mr. Rullo wants to talk about 3 and 4.
I'm so sorry, board. I just wanted to, for number 1, I just wanted to make it clear for the record that that was petitioner's continuance request.
Right, but it had been approved prior to the meeting.
Yep, that's fine. I just, so that's
okay. Thank you for clarifying that. Is everyone else okay with going to items 3 and 4 for comments from the city? Okay, let's turn to Mr. Rullo.
Well, I guess the first question is whether or not the appellant or the representative of the appellant is here for those. I did have an update, but I didn't want to.
They were not there a few minutes ago. Melissa, have you heard anything different?
I don't know that she can hear us, and we can't.
I don't think she can. Oh, no.
All right. The last we knew, Mr. Rullo, as we were getting started, there was no one here for 3 and 4.
Okay, well, I guess then it would be up to the board's discretion.
Unless you want to wait.
What they're going to do. Yeah, I leave it to the board's discretion.
15 minutes, Nancy?
That should probably be it, but we don't know how long it'll be till we have sound and can go ahead with 2.
Well,
if they're not here, then the city would be requesting that the appeals be denied for failure to appear. But I know that we're
okay
8 minutes in, but
we'll deal with it when we get there. Then let's see what's happening with case number 2.
Okay.
Melissa, do you have sound for that?
Hold on 1 second.
No, we can't hear you, Melissa, if you were trying to get confirmation.
Can everybody hear me now?
Can hear you, yes.
Great. All right, so I'm going to put case number 2 in.
Okay, very good, thank you.
Michelle Wall, yeah, come on in. Just have a seat and just project really loud. Okay, thank you very much. You're ASAP real estate, correct? You're going out. So is voice here? Yes. Okay. Hello.
Hello, give you a moment to get situated. And while you're doing that, I'm going to announce the case. This is for Donna Showell, last 4 digits of the docket 6685. Property address is 7207 Devon Street.
Yes.
And when you're set there, please identify yourself for the record.
I'm Donna Shale.
Do you swear or affirm to tell the truth with everything that comes before the board?
Absolutely, yes.
Okay, and when it comes time for you to actually be talking, if you could be a little closer to the mic and speak up so that we can clearly hear what you have to say. Who has this matter for the city?
Good afternoon again, board members. This is Michael Rullo, R-U-L-L-O, on behalf of the city of Philadelphia. And our witness today will be Miss Eileen Fonseca.
As well as Martin Higgins.
Thank you.
You're welcome.
Please identify yourself for the record.
Good afternoon, Eileen Fonseca with License and Inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
And you indicated there was someone else who was
Yes.
going to be testifying. If they could identify themselves for the record, please.
Martin Higgins, Community Life Improvement Program.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Okay, who has the numbers for the record?
I do.
Please identify that information for us.
So this is the property located at 7207 Devon Street for a clip abatement bill. Bill date is October 25th of 2021. Bill number is 21-008614. Principal amount is $117.06. Administrative charge is $24.58. The interest is $8.40, totaling out the invoice to be $150.04.
Okay, does the city have any other comments before we turn to the petitioner?
I just had a brief opening that I believe could help narrow the issues depending on the board's ruling here. I will be very quick with it. So in this instance, board members, the appellant did not file an appeal of the underlying violation notice to the Board of License and Inspection Review. In these circumstances, as I believe the board is aware, it does not have jurisdiction to rule on the validity of that underlying notice of violation. And instead, its authority, as you know, is limited to determining liability for any unpaid money or claim, license fee, or other charge. So the city's position in this instance is that The board cannot make a determination as to validity of the underlying notice of violation. Those issues are decided. And so the only matter before the board at this point is whether the city performed the abatement work and issued a valid invoice. So in this instance, we believe that we can narrow the issue substantially to those two matters, and then the board would have a sufficient record to make its determination. So that would just be our initial presentation or issue to raise.
Okay. I'm a bit confused about that first statement that in terms of what gives us jurisdiction, that the petitioner should have done something before coming to this board. I'm not clear on what you were referring to there.
So to dispute kind of the facts surrounding a notice of violation and whether it is upheld as a valid violation, whether it's affirmed or the appeal is granted, is something that has to go before the Board of License and Inspection Review. So the facts underlying a notice of violation was the violation, did the violation conditions exist? Did those, can you dispute those underlying violations? That can't be decided by the Tax Review Board. That's something that goes before the Board of License and Inspection Review. And by failing to take that to the Board of License and Inspection Review, the underlying facts of did this violation exist? Is this a valid violation? Cannot be disputed here. So those facts are essentially admitted, meaning the only question before the board in this instance is, was the work performed and was a valid invoice issued?
Okay. I'm just trying to figure where we go from here, because I don't remember having experienced something that was set up quite this way. Do other board members have any comments on that?
The petitioner is here, what she has to say.
Can I ask a question? I came and I appealed this before, and this is an appeal hearing. So I was here before about the condition of the yard and what they were saying they did. And I appealed that, and that's why I'm here today. I think that's
we understand that, but the city's attorney is just explaining what he believes the Tax Review Board's jurisdiction is, what kind of decisions we can make in regards to this case. As Ms. Board Member Weiss said, perhaps you should begin and explain why you're here today and what you're looking for this board to do for you.
You want me to explain?
Yes.
Yes. What your position is on this, and as clearly as you can.
When I got the notice about work that had to be done at my home, I have a landscaper who keeps my property. It's a rental property. I have my receipts for them doing lawn care there. During the period that you're saying the city came and did work at my property, they did not do work at my property. I have receipts. I have a landscaper, Levi Gettings, maintains my property. Not only is my property maintained properly, but in the back, my tenants can put down tables and have like little cookouts out there. I did have trees there, which I have taken down. My property in the back is empty, and I bought pictures, and I also bought receipts for having work done. I also have a receipt for September 21st when they're saying they did this work, where Levi went there and did work on the lawn. I don't even think they're talking about my property, which I can show you here.
We can't see that very well.
I gave some of the receipts to the young lady in the black and white top when I got here.
Yes, I've sent that to Mr. Rulo, who's the city's attorney, and I'm sending it to the board right now.
And this is the back. This is a copy of the back of my yard. The yard that they're talking about is not my yard. The yard that's next to me still has not been addressed. I don't have a lot of debris. And if you look at my receipts, it's impossible for the time period for all of that shrubbery that they're talking about grew. I have my receipts from 2021.
I just need to object here for a second. I received an email showing invoices. It appears that there are images being, that she has raising up on the screen that I can't view. If I'm understanding correctly, her indication is that the work that the city says we performed was not on her property.
That's exactly right.
I haven't had a chance to view.
We're all in the same boat. She just sent that out for all of us to look at.
I just received the email. It's only
right. We're all in the same boat. I just got a ping. I haven't even had a chance to get to it yet.
That's what I'm saying. I'm looking at that email right now, and those photos are not in it.
Our photos could not be put into that email because those photos are too big. So what I was going to do is just have them hold up. They're big enough where I think everybody can see them, but they're too big for me to scan. They're like poster size. Ms. Scholl, can you show those pictures once more?
Sure. This is the back, this is the rear of my house.
Hold it up.
Here,
in front. Okay,
Melissa, if you will spotlight her, then she will show up big on the screen.
Hold on 1 second. Thank you for that. Forgot.
Pin her?
No, make her the
There we
biggest.
go.
Okay.
this is the back of my yard. This is my backyard at 7207 Devon Street.
is that a train track or something
Yes,
that's,
the train track is in back of my yard, yes. This is my yard, there's a train track, and the stuff back there is the property of the people over there. This is, I'm on this side of the track. That's one
So,
picture.
all right, I want to stop you, Michelle. So you're telling, your property is closest to us on that picture. Is that what you're saying?
This is right, this is my backyard.
Okay, I just want to make sure we understand so that your property's on this side, there's a train track,
And
and
then
that's
there's
somebody
stuff-
else's property, and we see a buildings. Okay, I just want to make sure we're.
is that
So
a tree
just-
stump?
So
There are tree stumps because I had the trees taken down so that the area could be used. And since that time, I've had the stumps taken out as well. There used to be poles up there to hang your clothes out. I took all that stuff down.
And what's the
Okay.
date on that photo?
I showed it the last time I was here for a hearing, so I think that was in 2021 I was here.
okay, so just to clarify, you're arguing that they never did an abatement on your property.
No, this is what I'm saying. They gave me a notice about work that had to be done at my property. When I came in, I told them that was not my property that they had given me the notice.
Okay, so you're saying that they never did an abatement on your
No,
property.
The city never did work on my property. They-
Okay, that's,
Okay,
That's the question we were
Yes,
trying to
thank
clarify.
you.
And I have receipts where I can show you.
Come closer to the mic as you're talking, if you would, please.
And I have receipts where I have a landscaper who does work at my house during the same period that they're saying there was an issue there, which I gave to the young lady in the black and white. And it goes all the way back to 2021. I can go all the way back. I gave her one, I think, from April. It's impossible between April and September that the debris that they're talking about grew. I also gave her a receipt for, this is August the 13th, 2020.
But those are payments that you made to a private
Yes,
entity, is that correct?
Right, my house, okay, 7207 Devon Street is a rental property of mine. So I have a guy that takes care of the grass, and I have a guy that takes care of the snow removing because I don't do it myself. I have people that I pay to do that since I purchased the property.
When did you take that picture, please?
Pardon me?
When did you take that picture? The
In
picture you showed us.
2021. And I have other, let me see if I have any more on my phone. I can show you more recent. I can show you all my receipts for people doing the grass because I cash app them.
Okay, so what it sounds like to me is that the petitioner is saying that she is paying someone to do the yard work on the property. So it's impossible that the abatement that's being alleged by the city was actually done because she has receipts proving such. City, do you have anything to refute that?
We have photos that I've included as city exhibit, excuse me, I believe it is B as in boy, showing that there was abatement work done.
Okay, so can we do your case in chief then at this point, so that way we can get that into evidence?
Actually, what I was going to suggest at the moment is, based on the photos that Ms. Scholl has presented, I am wondering if we could take just a brief recess so that I can speak with the city's inspector about this. That would be my request at the moment. Because again, we haven't been presented with any of these additional photos or this prior to now. And just based on what's been raised, I would like an opportunity to consult with Mr. Higgins to see if there could be a resolution here.
Okay, can I say this to you? The pictures that I'm showing you now, when I had my first hearing here, they said there was an attorney on here, a heavier set African-American man, that I gave all this stuff to.
okay, well, we're here now, so let's see if we can take.
Okay, okay,
And
yeah,
you're saying it
let's
was
see.
just one person that you had a hearing with before?
No.
It was her master level hearing.
That's what I just was going to get that clarified on the record, that was the
So-
master's level.
How about if we take 10 minutes?
Thank
and
you.
let Mr. Rollo look at the information, because truly we've all just gotten it. Talk to your witness, Is that all right with the rest of my board members?
It's fine with me.
I will also try to grab the pictures and see if I can scan it and send it to everyone because they were very large, but I can try on.
Okay.
If you know what,
Okay.
Melissa,
Thank
you
you.
take a picture of the picture, maybe?
Oh, I'll try that. Okay.
Okay, all right, so let's take 10.
I think
All right, Mr.
Okay.
Remo? Becky?
Thank you.
Thank
Okay.
you.
Okay, and I think we should all be muted. Is that an appropriate thing?
All
at
right,
this
so
point?
2:35, we're coming back.
Correct.
Okay, thank you.
I'm trying to find these pictures on my phone as well, but here's these. They didn't do any work at my house.
Shit.
You know, the other thing that's funny is when you shake the room.
You're meeting with my neighbors? Huh? Hello? Yeah.
Now we're in. Okay. That's news to me. All right. Wondering what he was doing. That's what I was wondering what he was doing. They didn't have to want me. I know. I was like,
Hey, Melissa,
Yes.
if you want to remove her spotlight, it's in the top left corner of her picture. Yeah, sorry. I didn't know. You
No,
saw
I
it.
just appreciate you. Every time you teach me something new, I really appreciate it. Thank you.
Oh, yeah. Well,
okay. Thank you. Okay.
we're getting close to the time we had set. Has the city had enough time for their consultation? I got a head shake on that. Was that a yes?
That is a yes, thank you.
Okay. Head shake was probably appropriate under the circumstances. Okay, as we've said, 2:35, and by the clock on my computer screen, it is 2:35. Is everyone ready to resume?
Yes, and the city's ready to put its case in chief on. I appreciate the board's opportunity to allow me to discuss that photo with my client first.
Okay. So I guess that was what we needed to do, is to have you had that consultation time, and you were going to come back with some information for the board.
Yeah, so after reviewing that with my Inspector Higgins, the city's just ready to proceed with the case in chief. It should be
the city's ready to what? I'm sorry, I lost.
Proceed with its case in chief.
Okay.
Sorry, Mr. Higgins, thank you. He was muted. Thank you. That's where the noise was coming from, Nancy.
Okay.
With the board's permission, I'd like to share my screen.
Please go ahead.
Can everyone view what has been preliminarily marked as City Exhibit A on the screen?
Yes.
Yes.
And just Inspector Higgins and I were having this issue before, so just to clarify, Inspector Higgins, can you see this as well?
He's on. Okay,
Yes, I can.
Okay, great. So again, this is what has been preliminarily marked as City Exhibit A as an apple. I'm moving to the next page here. Inspector Higgins, what is this document?
It would be a notice of violation in order to correct.
Okay, and for what property is this notice of violation issued?
You're on mute.
I'm sorry, 7207 Devon Street. There's a lot of going on in the background.
Okay, and what is the date of this notice again?
It's August 12th, 2021.
And what did this cite the property owner for?
Overgrowth in the rear.
And actually, excuse me, before I forget this, what address was cited here for the property owner? What mailing address was listed here for the property owner?
And 8802 Marshall Road in Glenside, Pennsylvania.
And the responsible party was listed as Donna Scholl, correct?
Yes, that's correct.
Moving down now to what has been preliminarily marked as City Exhibit B as in boy. Do you recognize this photograph?
Yes, I do.
And what is this a photograph of?
That's a photograph of the rear property at the railroad embankment. I received a complaint for 7201 with the same conditions, and it ended up issuing blanket violations for 7201 Devon Street down through 7209.
Okay, and just to kind of, I guess, put this photograph in perspective. So am I correct that the rear of the subject property is behind the person taking this photograph? Is that correct? You're on.
I'm sorry. Yes, the back of their properties would have been at my back when I took that photograph.
Okay. So we go from.
Say that again. I'm sorry. I missed part of what you said.
So when I was taking that photograph, I was facing the railroad, which runs through the center of two streets. My back was facing the back of 7207 Devon Street.
And so to further clarify that, so that the board can understand kind of the dynamics of the structure here, we have the property, a paved area, trees, and then the railroad tracks, correct?
That's correct.
Okay, and this is, you're standing on that pavement, viewing
That's
the
correct.
trees, and then behind those trees is the railroad, correct?
Yes, that's correct.
And the condition that was cited here, and the date of this photograph is August 11th, 2021. It's for these weeds that are here, correct?
That is correct.
Okay, and that's what the city performed the abatement work on, correct?
That is correct.
Moving to the second photograph here, it's now dated September 21st of 2021, correct?
That is correct.
And this is taken from that same perspective of the pavement at the rear facing the weeds, and behind that is the railroad tracks, correct?
That is correct.
And this photograph is showing that those weeds are still in that same condition that was cited in early August, correct?
That is correct.
Okay. And I'm moving to the third photograph now. And this is another photograph after the abatement work was performed. Is that correct?
Yes, that is correct.
And this is showing that those weeds had been trimmed and that they were trimmed by the city. Is that your understanding?
Yes, it is.
And again, you were at this property, correct?
Yes, I was.
Okay. And so again, just for clarity, we had those weeds that were cited as the condition in the notice of violation. That notice of violation was not appealed to the Board of License and Inspection Review, correct?
Yes,
And it was not corrected within the time provided in the notice of violation, correct?
that is correct.
And that's why the city went back out here on September 21st. And as you witnessed, conducted the abatement work on those weeds, correct?
Yes.
Okay. And now I'm going to move down to what has been marked as City Exhibit C as in Charlie.
Mr. Rullo, can I ask a question before you, just a clarifying question?
Of course.
Thank you. And I'm not sure which one of you would be able to answer. Is this a public sidewalk or is this a sidewalk that belongs to the property 7207 or 7201-7209?
No, it's a common driveway. So basically what happens is their property lines extend through the driveway and up to a point of that railroad embankment.
Okay, so it's like a public driveway for the entire
Yes.
block. Is that how that works?
Yes.
And then how can we be sure, since you did say 7201-7209 were issued blanket violations, I believe, how can we be sure that this is the photo of 7207?
Because each case will have an individual case photo for a violation. I don't just take a blanket photo and say, like, figure out your property lines. I go by that type of information.
Thank you.
And is this roadway wide enough for vehicles to travel on them?
Yes.
Yes, it is. And I want to say 7211, there's actually a break in the row where you can access the driveway there, or you can go at the top of the block and access the driveway straight through.
And so just to provide some additional clarity for the board members to understand what the back of this property looks like. So the entire backyard of this property up until where we're seeing these weeds is paved. From the rear of the house all the way to where we see these weeds is paved, correct?
Yes, that is correct. There's like there's a slip for you to park a car, and then there's, I believe, a garage door.
Okay, and then this area that we're showing of this property, the weeds, that's still within the property lines of the owner, correct?
Yes.
And that's why they are responsible for maintaining this area where the weeds were cut.
Yes. So like, for instance, if you were to go further up the block, the space that this part of the block has, it's much narrower than when you go up to say like 7235, where it's like an accessory yard size.
Okay, I believe that clarifies the board's questions. So just as, and I'm not sure if there are any other questions from the board members in terms of these photographs and what's happening in the backyard here.
Could I see the pre-photograph again?
Yes, so just for the record again, there are 3 photos in Exhibit B as in boy. There is this first photo from August 11th of 2021 when the notice of violation was issued. There's the second photo, as Inspector Higgins testified, from September 21st of 2021. And there is this third photo from that same day, September 21st, 2021, and with the timestamp being approximately an hour later.
Thank you.
Okay. And then finally, I'm moving down to Exhibit C as in Charlie. Inspector Higgins, what's displayed in this photograph?
That's the abatement bill and invoice.
Okay, and what's the address listed on this again? For the mailing address?
The mailing address is 8802 Marshall Road, Glenside, Pennsylvania.
And the address on here is October 25th of 2021, correct?
That's not the address.
That's the invoice date.
Correct. Chairperson, I was just noting for the record that the mailing address that we sent this invoice to was the mailing address of the appellant. And the reason why I'm raising
I'm sorry, I misunderstood what you were saying.
And just to clarify, to put that in context, the reason why I'm raising that is the same address that is on the appeal form filed by the appellant. So I'm just raising that in terms of if there were any questions as to the issue of notice. Just to put that in context.
I never said there was an issue of notice, and I never said that I didn't live at 8802 Marshall Road.
Right, Ms. Scholl, that's okay. The city's putting on their case now.
We'll come back to you. Is there anything else from the city?
No, not in terms of testimony. I just reserve a short amount of time that I don't think will be necessary to respond to anything that's raised by the petitioner.
Okay, any questions from board members for the city? Hearing none, then let's turn back to the petitioner. Do you have anything to add for our consideration?
I can add, I never denied that I lived at 8802 Marshall Road. I never denied that 7207 Devon Street was my property. What I have said is that that was not my property, where they said they did work. I showed you receipt. Why would I pay somebody to do work if they didn't do the work? It doesn't even make sense.
Did you ever take care of that area that was used by the city in their testimony? That I'm saying, I shouldn't say used, but there's referenced the pictures that they had.
When I bought my property, I think it was like 2002.
Please get a little closer to the mic.
When I bought my property in 2000, I think it was 2002, in the back, there's two driveways. There's a driveway and two garages. I knew it was my responsibility to keep the front and the back clear. And there's lines that go through. There's, I guess you call them power lines. If debris grows over the power lines are going to go down. So I would not allow that to happen. And again, when I bought the property, I got a landscaper who maintains the property for me. Weeds, grass, snow, because I don't do it myself.
You saw the information that the city provided in terms of the area they did work on.
And I will tell you.
Did you consider that your property that they were working on, or
no, I do not.
What did you consider that property to be?
If you go over there right now, where you see those two logs and all that mess, I'm sure they're still there. It's a row. This is a row of duplex, and then up the street is houses. There's still a lot of debris with a lot of the people. They've done nothing. They've done nothing. So if they were to go there today, they probably would find people again. I don't not take care of my property. And no one's going to make me say I don't take care of my property.
If I may have an opportunity to cross-examine the petitioner, unless she has questions for Inspector Higgins.
Does any other board member have a question right now? Turn to the city then, go ahead.
Okay. Give me 1 second, and with the board member's permission, I'd like to display my screen again.
Please.
Ms. Scholl, can you see what I'm presenting on the screen here?
I see it says Exhibit B.
I'm sorry, I'm having trouble hearing. Could you get closer?
I said it says Exhibit B.
Thank you, ma'am. So you had indicated that the work that the city performed, you didn't think that was done on your property.
No, I do not.
Okay, so this area.
I think that's my property.
Okay, so you indicated that you have a landscaper.
Yes, I do, and I gave you the receipts for it.
And so where is that landscaper doing work?
In the front and in the back.
And so at the back of your property, from the edge of your building, starting at the edge of your building, there's pavement, correct?
It's a paved driveway.
Yes.
And
so there's.
If you ask me a question, I'm trying to answer. It's a paved driveway, and then that's where my two garages are in the back.
And so the area that your landscaper works is at the end of that paved driveway.
At the end, yeah, my two driveways, the driveway and my two garages, up above that is my property.
And in this photograph, we're seeing that there's an area of pavement, correct?
Yeah.
And at the end of that area of pavement, there's weeds.
Yeah.
Okay. And if we go down now to the third photo here,
yeah,
we see that there's the pavement. And then
I don't have any, I've never had anything taken down and left logs in my backyard. If that's not my stuff.
I'm just asking about what's in this photograph for now, ma'am. I understand. So in this photograph now, we have that pavement, and then we see that there's an area that had weeds cut, correct?
Yeah.
Okay. So at the rear of your property, at the end of the pavement, there is an area that that you're saying that you maintain that has trees and shrubbery on it, correct?
Exactly right.
Okay. And just for the record again, when you received this notice of violation that I noted in Exhibit A, correct?
Mm-hmm.
Okay. And did you appeal that to the Board of License and Inspection Review?
I came in for a hearing. So I don't know if I appealed it, but I came in for a hearing, which I told you I was here before for.
In front of the master of the Tax Review Board, is that correct?
I don't know. I know I came and I was in this room on video, and it was an attorney.
Can you get closer to your mic?
I said, I don't know what it was. I know I came here before. I think it was in February 2021. I'm not really sure. And I talked to a lady, there was a lawyer on the screen like this, and there was an African-American guy that was on it. And we went over all this stuff. I showed them my receipts, told them it was not my property. They said that, you know, I got a thing saying they were going to, there was a judgment against me and I could appeal it. And that's why I'm here today.
Sorry, so she was here in front of our board, in front of our
Yes.
master. Okay,
So that was not the L&I board. Were
no,
you at another board before
No,
you
I was
came to here?
I was in this place right here, 400.
Right, that's my question is, did you go to another place before you came here?
No, just here.
Okay, so that's the distinction. The one that he's talking about, that the city is saying you should have gone to first was an L&I board or L&I personnel.
I think I came around February 11th, 2022 at 2 o'clock because I have the paper right here.
Right, I know, but that would have been
Nancy,
tax
I think we
review.
know, she was here. She was here,
Yeah.
she didn't go anywhere else, she started here.
That's
The tax review board, so that kind of
that's what we're
solved
clarifying.
that issue.
That does it for my questions for the petitioner. City's ready to proceed to closing, and I will be very brief.
Okay. Do any of the city, excuse me, do any of the tax review board members have any questions or anything else you want to address? Hearing none, if the city has closing comments, please make those now.
And I will be very quick here. So returning back to the point that I said earlier, it's the jurisdiction of the Board of License and Inspection Review to rule on the validity of a notice of violation. Here, the appellant is disputing whether or not that notice was valid, specifically whether or not the area that was cited was on her property. And so what I was trying to elicit earlier is the fact that if she's disputing the validity of this notice in terms of whether these weeds and these conditions existed on her property, that question is within the jurisdiction of the Board of License and Inspection Review. Here, it is whether or not simply did the city issue at this point a valid invoice for work that was performed. And so that's the distinction in terms of what TRB does and what Blur does. And what our position here is, as Inspector Higgins testified regarding these photographs, which he personally took, he went out there, he testified that he stood behind this property, that he took these photos, that he took the photo in August showing those weeds, issued the notice of violation that was not appealed, came out more than 30 days later, the conditions still existed. He took a photo of them still existing. An hour later, he took an additional photo while he was still there after he's testified that the city performed the work. So we have a witness here who an hour before took a photo of the condition still existing, and an hour later after he says that the city performed the work, showed that the weeds had been cut. We think this is pretty cut and dry. The city's entitled to get a rebate.
I have something to say. $100 and some is not a lot of money. It is the fact that it's not factual. And I would not have trees cut down and leave logs in my backyard, like you're saying were left in the back of my property. That is irresponsible, and I wouldn't do it, especially with tenants where I could be sued if somebody got hurt. It doesn't make sense to leave logs in your backyard. So I don't care who came out there to look. I know what I've done, and I know how I maintain my property. And it's the principle. I don't like lying on, I don't like being lied about. And I know what I did. And I have all my receipts for having landscaping done at my property. I'm not irresponsible. Thank you.
Thank you. So does the board want to step aside?
Yes,
Yes,
I do.
please.
If everyone can just hold tight, the board is going to go into a virtual waiting room. We will be right back.
don't know how long they're gonna be.
Okay, everyone is back, Nancy and Paula.
I've asked Paula to state our decision for the board.
The board has reviewed all the evidence presented by both parties, and it is the decision of the board unanimously to grant this petition and abate the bill. Our determination was that petitioner met her burden of proof to establish that it is very unclear that work was performed behind her property and that she did have proof of maintaining the property that belonged to her. Ms. Scholl, you're going to get a letter from the Tax Review Board within 2 weeks with that decision that the bill is being abated. Either party may appeal to the Court of Common Pleas, and we'll have 30 days from the date of that bill. And that concludes this hearing unless either party has a question. Hearing none, we're going to move on.
We thank you all for your time and effort.
I did just have a very brief question. Was there a conclusion reached by the board in terms of the jurisdictional argument that we raised of whether or not that could be disputed? If not, I understand. I just wanted to clarify whether or not that point was decided.
That wasn't part of our decision.
Okay, thank you.
We're looking purely at the bill and the reasonableness of the bill.
Thank you very much for coming in, and you'll get a letter from us that spells out that decision.
Nancy, George Matthews, I concur with the decision.
Dominic Ward, I concur with this decision.
Paula Weiss, I concur.
And Nancy Cameradiner, I concur. Thank you all. Let's see,
Excuse me, members of the board, this is my last hearing. May I be excused?
Yes, you may.
Thank you.
Thank you. Let's see, we had items, let's see, did we finish with 3 and 4?
No, but we are doing case number 5. We will adjust.
I'm sorry, I can't.
We will adjust 3 and 4 after we finish 5, because 3 and
Oh, okay, okay.
Oh, Melissa?
Yes?
You know what? The mic seems to have dropped down.
Right, we can
Volume.
barely hear you.
Okay, 1 sec.
It was getting weaker and weaker.
Okay. Hello?
We heard you that time.
All right, is that better?
Yes, much better.
Okay.
It's better. It's not great.
Not great? Okay, we'll have to figure this out. Just speak really loud.
But at least I'm hearing you. We're dealing with item number 5 for ASAP Realty Investments Inc. Last 4 digits, the docket 9232. Please identify yourself for the record.
Hi, my name is Jordan Anderson. I am the owner of ASAP Realty Investments.
Okay. Do you swear or affirm to tell the truth with everything that comes before the board?
I do.
Okay, fine. Thank you very much. Who has this matter for the city?
Caroline Curley, Curley, counsel for the city.
Okay. Do you have anyone else who's going to be joining you from the city?
Do you mean witnesses? Yes,
Yes.
I have 2. Correct.
Please identify. Please
The
identify
department will
yourselves
be
for the record.
presenting Miss Eileen Fonseca, who will be reading the numbers in, and Supervising Inspector Thomas Rebekowski for the remainder.
Okay. Ms. Finesca,
Fonseca.
I'm having trouble pronouncing it. Finesca has already been sworn. Is Mr. Rebekowski, please identify yourself for the record. Is he there?
He is. He's just showing his camera.
I am. For some reason, the camera wouldn't turn on right away, but
Okay.
Thomas Rebekowski, City of Philadelphia, license and inspections.
Do you swear or affirm to tell the truth with everything that comes before the board?
Yes.
Thank you. If we could have the numbers for the record, please.
Sure. So this is for the property located at 4422 Germantown Avenue. Bill date is January 21st of 2021. This is for a demolition. Bill number is 20-006396. Principal amount, $65,777 even. The administrative charge is $13,813.17. I do not have any interest at this time for this bill. So that totals out to be $79,590.17.
Okay, thank you.
You're welcome.
Does the city have any opening comments before we turn to the petitioner?
Yes, as an initial matter, the city is objecting to this appeal proceeding. It's my understanding that the board granted nunc-pro-tunc relief without giving the city the opportunity to have a hearing or object. This bill was issued on January 20th, 2021. The deadline to appeal this invoice was March 21st, 2021. The petitioner did not appeal until April 2nd, 2021. They've offered no reason as to why the petition was filed late. There's been no evidence of a breakdown or any other, unexcusable reason beyond the petitioner's control why this wasn't filed timely. Therefore, the board lacks jurisdiction to hear this matter, and non-pro-tunc relief isn't warranted. So we would ask that it be dismissed on that basis.
I just want to verify that we did indeed provide that non-pro-tunc relief. I don't have that in front of me. Melissa, do you have that verification?
Yes, the dates are correct. The petitioner filed their petition on April 2nd of 2022, and it was approved non-pro-tunc by you, Nancy, May of 2021. I'm sorry, the petitioner filed in 2021.
Okay.
May of 2021. So.
Okay, thank you. The board often agrees to non-pro-tunc approvals based on information that we've looked at and reviewed, and unless I'm hearing any other objections on it, the board will want to proceed in this matter.
Yeah, I think the issue the city has is we aren't provided with those reasons, so we don't have an opportunity to object. So we're not aware of what those reasons are.
Okay. Okay, understood, and that'll be part of the record. Do you have anything else to provide before we turn to the petitioner?
Yes, just additionally, so the board has a little bit of background. This was an emergency demolition that was performed at the property at 4422 Germantown Avenue. Our evidence will show that the department determined this property to be unsafe on October 26, 2020. Notice was sent to the petitioner at all of the addresses that the department had of record, which were all consistently the same and matched the petitioner's address on his petition paperwork. The department, because of an emergency call from the Philadelphia Fire Department, returned to the property on November 1st, 2020, and the building was actively collapsing on the third floor. We'll have pictures to show that the building was in an active state of collapse. Due to those conditions, the department moved forward with securing the lowest bid to do the emergency demolition and abatement of those imminently dangerous conditions. The department additionally sent an imminently dangerous notice to the petitioner. The department additionally properly placed notice onto the property in a conspicuous place so that the petitioner had all the opportunity to see those violations. I would additionally add that the petitioner sent exhibits to me about an hour and 15 minutes before the hearing was supposed to start. And in that packet of paperwork, the petitioner tried to file or started to file a temporary restraining order on November 4th, I believe. The paperwork was dated to stop the demolition. And on, just so I have the date correct, on November 4th, 2020, through his attorney, that matter was voluntarily marked as discontinued. So that matter was ended before a hearing was even held on the restraining order to stop the demolition. The demolition began on November 6th, 2020 by the lowest bidding contractor to remove the collapsing roof. It was completed on January 8th, 2021, generating a bill consistent with what Ms. Fonseca has already stated, totaling $79,590.17. At no point did the petitioner ever file with the Board of Building Standards or any other administrative board for any of the violations cited, either unsafe or imminently dangerous. So they are not contesting, they have not properly contested the status of those buildings. So we are simply here for the bill. And I would also add that at no point, at any point, either from the initial notice in October of 2020 up until the completion of the demolition, did the petitioner ever obtain or even attempt to obtain a make safe permit to render the building safe. So with that, I rest my opening and would just have Inspector Rabakowski remaining.
Okay, we'll come back to you then, but let's hear from the petitioner. Please tell us why you're here and what it is you're looking for from this board.
Yes, I'm here because it's my belief that I wasn't given the opportunity to properly address the matter itself, whereas the demolition contractors that the city used it's almost like they play by a different standard, where the number of documents and safety measures required for the city approved demolition contractors are totally different and much lower than it is for me as a private citizen. To address the matter, when it did, when the collapse first started and the unsafe violation was placed on the door, I received a notification by mail probably about a day later. It was either next day or within 2 days for the imminently dangerous violation. That notice in the mail didn't come until a week after the building had already been demoed. And to address the issue with filing for the petition, I didn't receive the actual petition until the end of March, which is why I filed the appeal in April. So when I first got the notice of unsafe, that was during COVID, all the city offices were closed. I tried to come downtown to speak with somebody, ended up finding, in a roundabout way, I guess, the process that I had to follow in order to try to save the building. I can't apply for a make safe permit until I have the engineer's reports and everything else like that. And within the documents that I provided, you can see where I reached out to a couple different engineers. At least one engineer immediately filed when I was notified of the collapse. And then also I reached out to two different demolition contractors. Part of obtaining a make safe permit is identifying contractors, identifying engineers to then be able to move forward with the process. So as you can see, I hopped on that immediately to begin that process.
Could I ask you to go back a little bit before the time period when the emergency was being identified? When did you acquire this property?
I acquired it May 9th, I believe it was around about May of 2019.
Okay, and did you visit the property? Did you or someone on your behalf do work on the property in that early time period?
There was no work that was done. I did visit the property, and I also had, I was constantly in the area checking on the property, as I have 3 properties that are directly across the street. So that's kind of how I came to know about some of the things a little quicker.
Did you notice anything amiss at that property in that early time period before the dates that were identified for the identified by the city in terms of the emergency?
No, I did not.
You didn't do anything or visit, take pictures, or try to work on anything at all at the property in that early time period?
So I visited the property just to kind of like check the status. Pretty much after I purchased it, and then like I said, I would just kind of ride by and make sure that it was still locked up and secure. But as far as like periodically taking pictures or anything like that, I didn't do. There was no work that was done.
The city mentioned that it was collapsing. Did you ever notice anything before the time that the city sent out the notice to you that there was any failure of any portion of the property?
No, I did not.
I'm sorry I interrupted, but I wanted to take you back before, because that's a crucial time period in terms of what was done and what the prep might have been. It's one thing to start following through in that crucial period when things are all going bad, but what happened and what did you know about the property before that can often give us a perspective. I'm sorry I interrupted you there. Do you have other things to add in terms of your issues with the property?
Yes. So what happened was, and it obviously was condensed within maybe about a week time frame from the time that the first unsafe violation to then when the imminently dangerous was placed. Part of the reason why the imminently dangerous was placed, at least what an L&I inspector told me, as well as the construction company, was that I guess.
So I'm gonna just so the record's clear. I'm objecting on the basis of hearsay. This is all things that someone else told him.
Okay. All right, please continue.
So it's so that there was a daycare next door. The property owner of 4424 Germantown Avenue said that there was a daycare. I have pictures in the package that show the property 4424 when I first purchased 4422, and then I believe through I believe the latest it was like November 2019, where the daycare would have been quote unquote actively running. And you can see that there's really like no change to the exterior, where you would think that if there was a daycare, maybe signage or whatever. And then I also included in the packet the business permit for the daycare, which had already expired by the time the class started. And it was never renewed. So I'm not sure.
I'm just going to object as to relevance for all of this.
Okay.
Yes.
So noted. Thank you, Curley.
Thank you.
Yeah, so so it was my understanding that was kind of why things were fast tracked. But regardless of that, so I found out that the city had placed it on the imminently dangerous and they were to do the demolition because one of the demolition contractors that I actually contacted reached out to me because he's a city approved demo contractor, and he let me know that he saw that the property actually had went up for bid. And he reached out to try to basically tell me what the process would be to save the property. And it was in his estimation that it could be saved for about $15,000 to $25,000. So moving forward from that, I contacted the lawyer, contacted his recommended engineer. The lawyer submitted the TRO, but from my understanding with the lawyer, when they went in front of the judge, basically they were still requesting the full set of documents, and they wanted everything to be ready the next day, which would have been November the 5th. And that was just unfeasible for my team. So because we couldn't have everything ready the next day, which would have included like stabilization plans, bracing plans, and all of the different things that are needed to safely do a selective demolition. That's why we withdrew, because we knew that we wouldn't be able to hit the timeline. And then so the city could continue with their process. So then I also included in the packet pictures while there was demolition. So demolition actually started the next day, November 5th. You'll see from the pictures, they placed the gate in front.
Do you have those pictures here? Do you have them to show to us?
They were included in the link that I sent. I can, if you have the link, I can, or am I allowed to?
Did the city, did the board receive that, Melissa?
Yes, Nancy, I had informed the board earlier that the lateness of the.
Oh, this is, okay. I was mixing this up.
I would ask Ms. Curley though, if you have them, can you share your screen? Because that's the only other way the board is gonna be able to see it. I sent it to the board, but Ms. Curley, do you still have them? Or can you share your screen if you have them up?
Yeah, it's just gonna take me a minute since,
Sure.
Yeah, I apologize for late submission. On the paperwork I received, it didn't specify a date which the exhibits had to be submitted by.
Yeah, so Mr. Anderson, none of your picture, nothing's really marked in order. If you want to direct me with the file name, then I can pull it up.
Okay.
I mean, the city has its own photos that might be helpful, which I could also provide. I don't know if they, I want to obviously give the petitioner the chance to go forward, but it might streamline things.
Yep. So if you go to
So I guess, Mr. Anderson, the question here is, are you arguing the building should not have been demolished, or are you arguing that the city's billing was unreasonable and too high or overstepped? What is it that you're exactly looking for our determination to be here?
So I am aware that obviously there was a defect to the building. It's what I'm saying is that the bill, the actions and the bill were too much, and it could have been done much cheaper if I was able to use my city approved demo contractor.
And do you have any documentation? I know you have in your packet from that contractor to establish what their price range or billing range might have been?
Yes, I have a text message which states what it would have been.
Okay. And is that printed out?
It's included. I can tell you that. Yes. If you can pull up demo start day 1, 11/5, pick 3.
And while she's trying to do that, you testified that you drove by periodically and looked at the building. Did you ever go into the building, or did you ever go and look at the rear of the building?
Sometimes I would. Yeah, not like I said, since there wasn't really any work going on. Like I said, just besides like making sure that the building was secure, I'd go in, make sure that back door was still closed, and make sure that everything was fine.
I'm ready for it.
Oh, go ahead.
Please let me know if you can see this photo. Ever.
Not yet.
Here it comes.
Yep. So this was the how the property was left at the end of demo day 1. So they demoed the 3rd floor, which only goes about, I guess, a third of the way. And as you can see on the left side, what the front looked like, and then on the right side at the end of day 1, the piece that fell and collapsed onto the 2nd floor still existed. There is no bracing. There is no fencing in the rear that would have stopped the neighbors, if there were daycare kids next door or anything, from being injured if everything were to continue to collapse. So with L&I in obtaining a make safe permit, I would have had to provide bracing plans and stability plans and everything for this controlled demolition. But as you can see with the city approved demolition, there is no bracing, no guards, no anything. And this is how they left it at the end of day 1, where the 3rd floor was taken down, but the piece that actually fell onto the 2nd floor and caused the 2nd floor wall to be unstable, all that still existed without any bracing.
So this is after the city started the demolition.
Correct.
Okay, I'm not sure how relevant this is to our determination regarding the billing process for it or the billing amount for it. I mean, I understand what you're saying, that perhaps the city contractor did not follow the safety regulations necessary, but that's not really in front of us at this point. And we don't have jurisdiction.
That's after the demolition had begun, and really at that point it was out of your hands. Is that correct?
Correct. But so my argument is that if I was able to use a city approved contractor and take the route that they used without doing bracing and everything, I'd been able to have, I would have been able to demo this property to make it safe for $15,000 to $25,000. And that text message can be seen.
But that was after they had already started.
Well, no, so the message I got was before they started.
Oh, okay. I'm sorry. You did mention that you wanted to talk to them about coming in and taking over. Okay.
Correct. So that one can be found. So if you can open up the Mangual Demo Contractor Convo 5. So Mangual Construction is a registered demolition contractor with the city. And they were the ones that informed me that the property had gone to bid that day.
Ms. Curley, can you zoom in on that? I can't read it. I don't know about anybody else. Thank you. Oh, thank you.
And
I mean, the city's just going to object to literally all of this. I don't want to like drag everything down, but this is all hearsay. We have no idea who this actually is. And that person's not here today. And I'm just going to also say that this is irrelevant. So all of this.
We understand, but we wanted to get a little bit of a sense of what the petitioner was talking about.
Sure.
So I'm not sure. So this conversation took place. Took place on November the 3rd. So this was still before demolition started. So this is where I asked for a rough ballpark to make it safe. He says between 15 to 25,000. And then he's saying, that's taking down the top to the first floor, removing the bricks, the joist, the roofing material, and everything. So basically, it would have taken it, would have demoed everything down to the first floor in the rear of the property, made it safe, and resolve the city's violations for the collapsing third and second floor wall.
Do any of the board members have additional questions to ask or other issues that need to be addressed before we start to consider anything more?
I have some questions for the petitioner.
I was asking the board before we came back.
Sorry, I just hearing nothing. I just kind of jumped the gun.
I got a couple of head shakes, and then the rest of you I can't see. But I don't think there were any actual issues that the board wanted to raise to the petitioner before we went back to the city. Is that correct?
I think that's correct. Let's turn.
Okay. So we'll turn back to the city for any other comments that you want the board to be aware of and be concerned with before we go further on our consideration. Okay.
Just for the petitioner, we'll start with this screenshot that you can see here. You'd agree with me that this is just a ballpark estimate by this alleged contractor, correct?
It's correct. It's an estimate where he's a contractor that's registered with the city and does a lot of demolitions. So even though it's a rough estimate, I'd say that it's—
No, that's it. That's it. Thank you.
She just wanted to confirm.
Yep. And you had no contract with this alleged contractor, correct? Nothing signed?
Correct. We needed there was nothing signed.
So you needed additional things, like you mentioned an architect, you mentioned plans, you would have needed additional things that would have cost additional money on top of this estimate, correct?
Correct.
Okay. And once you got this estimate, this is also, he's just indicating, moving it down to the first floor. This is not an estimate that reflects, removing the entire structure. Is that also correct?
This is the estimate to make it safe and resolve the city violations.
And are you an engineer?
I am not.
So on what basis, do you have any indication, how do you know that this would have made the building safe?
I go by the trusted professionals' advice, especially since they don't have engineer reports when they do demolitions. That's.
So so you have no idea, you have no expertise on that. You were relying on someone else's opinion.
No, I was going based upon the city's violations, which was a collapsing third and second floor wall. So if you take down the third and second floor wall, that resolves those findings.
That's your understanding of it. You're not a contractor or an engineer for that.
That's my understanding per reading the violations.
Okay, and you have no you had no plans of the building or anything else to make that assumption about what it would take to make the building safe.
To make the building safe would be to resolve the findings, which were the collapsing rear, third, and second floor wall. That's your understanding. You don't think you need engineering plans to do that? based upon the city's approved contractors that demoed the building, didn't have engineer plans. I'd say that there shouldn't be any difference just because it's a city contractor versus a private individual.
Okay. I'll just go back to, I also wanted to reference the photo you took that was January 5th, correct?
Which one?
The one that you showed the board, you asked me to show the board?
The photo that I took of it?
Correct.
That conversation was from November 3rd.
I'm sorry, the photo that you showed the board of the active collapse, that was November 5th?
Yes.
Okay.
Yeah.
And I also want to go back to your court case that you filed on January 4th. You voluntarily withdrew that, correct?
It was withdrawn because it was infeasible for us to provide all the documentation that was over and above what the city contractors had to provide by the 5th.
And but you withdrew it.
Correct.
And at no point after did you refile?
I couldn't refile because demolition began the next day.
But it didn't conclude until January. At no point from, from November to January did you attempt to refile?
Demolition actually concluded within 4 days. I believe demolition was wrapped up around November 9th.
And that's your opinion, correct?
I don't have pictures included, but that's my opinion that I saw with my own eyes.
Okay. And at any point, at no point did you attempt even to obtain a make safe permit?
I did attempt to obtain a make safe permit, but I needed the reports before a make safe permit could be submitted for it.
And you didn't obtain those?
They were not obtained, but I did attempt to obtain a make safe permit.
Right, but you just admitted you would agree with me that you didn't have an engineering report, you didn't have any of the other requirements necessary for a make safe permit.
Correct.
Okay.
It was not obtained, but it was attempted to be obtained.
But not with the department. You didn't file any of that information with them.
You can't.
Well, I think this has been asked and answered, Ms. Kerman.
Yeah.
We get
Okay.
it.
Yeah, I'll move on. I have nothing further for the petitioner. I'll just, call my witness when appropriate.
That would be now.
Yes,
thank you.
I was just going to say the same thing. Thank you.
The city would call Supervising Inspector Rebekowski.
Please go
And,
ahead.
oh, sorry. Go ahead.
Go ahead.
Oh, sorry.
He's already been sworn and introduced.
Great. Inspector Rebekowski, can you state your employer and position for the record, please?
The City of Philadelphia License and Inspections. I am a construction compliance supervisor assigned to contractual services or emergency response for license and inspections.
And just very briefly, what does contractual services or CSU do for the department?
We are assigned the task of declaring properties either unsafe or eminently dangerous, and then assigned the duties of inspecting the permits that are issued for either repairing or demolishing those said properties.
Okay. And are you familiar with the property at 4422 Germantown?
Yes.
Were you able to review all the department records on this matter?
Yes.
Okay. I'm going to start showing you some documents, if you don't mind. Let me know when you can see my screen. Can you see what's been marked as City Exhibit 1, or I'm sorry, A1?
Yes.
Just gonna try them. All right. There's definitely a wood. Sorry, court's indulgence. Really trying here. There we go. Okay. Moving down to A1, this is a copy of the Office of Property Assessment. Is that correct?
Correct.
This is for 44, the property we're talking about. and the mailing address is 615 East Tabor Road, correct?
Yes, according to the record for this property, according to the OPA, or the Office of Property Assessment, the property at 4422 Germantown Avenue, the mailing address is 615 East Tabor Road, Philadelphia, PA 19120.
Okay. And moving down to A2, this is the Pennsylvania Department of State, also showing same address for the owner, ASAP Realty Investments, the address being 615 East Tabor Road. Is that correct?
Correct.
And A3, this is a copy of the commercial activity license for ASAP Realty. Also, it's a little small, but showing a mailing address of 615 East Tabor Road. Is that correct?
This is a printout from the Eclipse system that a commercial activity license was applied for, or activity was started in 2015, and the address associated to this activity license is the subject, or the the prior referenced address on Tabor Road.
Great. Moving to Exhibit B, what are we looking at here?
You're looking at a violation notice in order to correct declaring the property at 4422 Germantown Avenue as unsafe. The date of the inspection took place October 26th of 2020. The date on this notice is October 27th of 2020. This notice was mailed to 615 East Tabor Road, which is the same address on that Office of Property Assessment exhibit.
And the violations are listed, but can you just kind of describe them for the board?
Rear wall, third floor, collapsing. We received a call into the department prior to this, requiring the inspector to go out to the location. They declared the property as unsafe for structural issues in the rear third floor section of the property.
Okay. And this notice was mailed out to the property owner?
Yes.
Okay. And an unsafe notice is also placed on the property. Is that correct?
Correct.
Okay. And moving down to City Exhibit C, we're now flashing forward a couple, I guess like about a week. What happened a week later?
So on June 1st, on November 1st of 2020, we received another call into the department. This came specifically from the fire department by way of city radio, with concerning the rear of the property collapsing further. And these are photographs taken by the responding inspector for that emergency call on November 1st of 2020.
Okay, so I'm gonna scroll in a little bit. What are we looking at here?
You're looking at the third floor rear section of the property collapsed off of the property and landed on the second floor section at the rear.
Okay, and there was some mention by the petitioner that you know this. Actually, strike that. I'll come back to that. Moving down to the next photo. What are we looking at here?
Another vantage point showing the collapsed section of the property, showing that the rear has collapsed and is basically landing on the other side of the property. This photograph was taken again on November 1st of 2020.
If I could interrupt, that is on the same property. It didn't fall onto another property?
Correct.
Okay, just wanted to clarify. Thank you.
So it's collapsing on itself. Is that more or less?
So you can look at the rear. The rear was this portion of the building was affixed to the third floor rear of the property. It completely collapsed off the rear and landed onto the second story rear section of the property.
Okay, fine. Thank you.
I have a question also. Mr. Bukowski, what kind of property was this?
It's classified as a vacant commercial property.
And it was a row property,
yes,
though,
it's
right?
the second. So with this property being on the 4400 block of Germantown Avenue, it's the second property in.
Okay, but it was all commercial.
They're all mixed use, but yes, they're commercial.
And this one, okay, thank you.
And we're looking at the back here. The front is
so right now what you would be looking at is the rear of 4422 Germantown Avenue from the vantage point of the neighboring property, which would be, if I remember correctly, 24.
And was that a commercial property too?
Mixed use, yes.
Mixed use. I guess I'm looking at this property behind it with the white siding, I guess. Is that somebody's house?
Yes, that is actually an occupied property.
An occupied property. And one other question for the property in question. Do you know what the square footage was?
Not off the top of my head, no.
Okay, thank you. Those are my questions.
I think that is on the OPA document, so I can look that up when I'm finished with everything.
Thank you.
No problem. Don't let me forget. Moving on to the next, we already talked about this photo, but let's move on to the next one. This is kind of showing the collapse on itself. Is that correct, Inspector Rebekowski?
Correct.
Okay. And this photo, what are we looking at here?
Another photograph of the rear section collapsed. It basically landed onto the other portion of the structure. And you can see the side load-bearing wall is actually pushed out towards the occupied property.
And when you say like side load-bearing wall, can you just explain the importance of that if that's collapsing to the board?
If this wall had failed, more of the structure could have collapsed, and it could collapse into that adjoining property, which was occupied.
Okay. And is there any way to predict, when that's going to happen, just looking at it with no plans or no information, just, looking at it?
No.
Okay. Moving on to this photograph. What are we looking at here?
Another vantage point of the side load-bearing wall of the property at 4422 Germantown.
Okay, and you can kind of tell in the center of the photo, it's pulling away from the window frame. Is that correct?
Yes, this is another vantage point. The shingles, or what's left of the shingles, they would have been what was affixed to that section of structure that fell onto the top of it.
Okay. And now we're looking at this photograph. What are we looking at here?
You're looking at the front of the property of 4422 Germantown Avenue following the inspection that took place on November 1st of 2020, where the property had been reposted and designated as eminently dangerous. You can see the remnants of the unsafe posting from the October 26th inspection underneath of it.
Okay. And this photograph, this is the front of the property, is that correct?
Correct.
And the posting is directly on front of the property?
Yes.
Okay. Now, on that date, what's the notice we're looking at here?
This would have been the notice of violation and order to correct that was mailed out by the department following the inspection that took place on November 1st of 2020. This notice was dated or is dated November 3rd of 2020.
Okay. And all of the violations are recited, and you've kind of gone through them with the pictures that this was, actively collapsing. Is that correct?
Yes, and the actual condition in violation is it's very specific. It's E-duty, which is the emergency inspector responding. Rear third floor collapsed, rear side bearing wall partially collapsed, second floor partially collapsed in the rear.
Okay. And there was some mention by the petitioner. Oh, I'm sorry. And the further violations that you mentioned, those are reflected on the page we see now, which I think is the third page of the violation. Is that correct?
Correct.
Okay. And there was some mention by the petitioner that the imminently dangerous status had something to do with a daycare being located nearby. Does that have anything to do with the department's designation as imminently dangerous?
No, the fact that it was in an active collapse and there was an occupied property next to it, that's the reasoning for the eminently dangerous declaration.
Okay. And moving down to Exhibit E, what are we looking at in this document?
The winning contractor that received had the lowest bid. This is the notice to proceed that is issued by the city's procurement department, notifying that Pedro Palmer Construction was awarded the demolition of 4422 Germantown Avenue for the bid price of $65,777.
Okay. And just backing up a little bit, what's the general process when the city needs an emergency demolition like that? How do they proceed?
We place the property out to bid to our demolition contractors. Our demolition contractors arrive on location and they will survey what needs to be done to demolish the property, and they will submit their bid. How many contractors show up and then how many bids would that we actually receive into the procurement department. In this case, we received 2 bids.
Okay, and that's out of, you send out all like bid requests to view the property or take the job essentially to all the contractors that are approved by the city, and who shows up, that you don't control that, correct?
Correct.
Okay, so in this case, you said 2 showed up?
To place the bid for this property, yeah.
Okay, and Pedro Palmer Construction, did they provide the lowest bid?
Yes.
Okay, and that bid is $65,777?
Correct.
Okay, and there's some notations here, and on the I guess middle section of the notice of procurement that this was an emergency demolition. Is that true?
Yes.
Above that, it says AIR required. Do you know what that means?
AIR means that this is a mixed-use property or a commercial property. It is a requirement of the master demolition program that any mixed-use property or commercial property requires a AIRS, which is AIR, and that is our abbreviation for asbestos inspection report.
Okay, and I think there's also a notation for 1 stucco C/W. Do you know what that means?
It is a requirement that for a demolition, once a property has been demolished and the exposed wall is open to the elements, we seal that by the process of installing stucco. And in this case, we applied stucco to one side for 4424.
Okay. And all of these things that we've talked about, the emergency demo, the air required, the stucco remediation, all of that, increases the cost of any demolition project that you've seen in your experience.
Yeah, in this case, yes.
Okay. And this is from Stephen Gallagher, the Emergency Services Director. Does this reflects that Pedro Palmer in fact submitted the lowest bid in comparison to FH Demolition?
Yes, this is a documentation showing that we received 2 bids for the demolition of this property, and exactly that. Pedro Palmer Construction placed a bid of $65,777, and then FH Demolition for $68,000. We awarded the bid to the lowest bidder, which was Pedro Palmer, for $65,777.
Okay. Moving on to City Exhibit F. This is now the inspection report. And it indicates in the, this is dated November 6, 2020. This is a department record, correct?
Yes.
So after, and it says in the inspector comments, posted and distributed letters to neighbors. Can you kind of explain the process about once a contractor gets the winning bid?
So for this property, the property was an emergency curbside bid that was awarded on November 3rd of 2020. This document was uploaded to our database, but the notice of posting or the notice of distributing the letters actually occurred on November 3rd of 2020.
Okay.
Place it out to bid. We also notify the neighboring properties that a demolition is going to be occurring. In this case, this was an emergency demolition. So our letters were actually distributed on November 3rd of 2020 when we placed the property out to bid.
And that's to make sure every neighbor around is, prepared for this and is notified of the, the amount of work that's about to occur.
It notifies the adjoining property, the neighbors at the adjoining properties, that a demolition is going to be proceeding, and that also they are going to have essentially a disruption for the next few days, next few weeks, in association with the demolition.
Okay. Moving on to City Exhibit 6, what are we looking at here?
This is the invoice that was prepared and sent out to the owner of the property, ASAP Realty Investments, and it was sent to the same address that was previously mentioned on the OPA, which is 615 East Tabor Road. It is for the demolition. It has the demolition cost, which is the same price, $65,777, but it also adds the administrative charge of $13,813.17, bringing the total due for the demolition of this property to $79,590.17.
And do you know the basis in general of the administrative cost?
The administrative cost is a statute where any abatement done by the city, there's a 21% administrative fee associated to that abatement.
Okay. And this also notes that the demolition was completed January 8th, 2021. Going to show you a city exhibit 8. What is this? What are we looking at here?
This is a photograph taken of the property January 7th of 2021, showing that demolition has been officially completed and closed out in our system, showing that the demolition is again completed. There has been an installation of the erosion mat, which is basically that green fiber that is placed on the actual grading. That is a erosion mat. It's specific to prevent erosion, and you can see that the stucco has been applied to the neighboring property.
Board City Exhibit I is simply a copy of the appeal paperwork that I received from the board for the petitioner's appeal. So I just asked that to be incorporated. And Inspector Rebekowski, the petitioner kind of testified that COVID, was affecting your office, CSU, and the application and receipt of Make Safe permits. Is that true? Can you explain to the board what the impact COVID, if any, had on your office?
So for my office, the division of CSU for license inspections essentially was not affected by COVID. Unsafe and eminently dangerous properties are just that, and the department had procedures in place that addressed unsafe and eminently dangerous properties. The department never stopped taking permit applications for unsafe or eminently dangerous properties. In fact, there was protocols on the city's website directing property owners how to apply for permits during the time of the pandemic.
Okay. And in essence, you're saying if the petitioner had come to CSU with all the paperwork they needed, they could have obtained a Make Safe permit.
Prior to the emergency occurring on November 1st and us placing the property out to bid, yes, they could have applied for a Make Safe permit. Once the emergency occurred on November 1st, then the owner would have been directed to file an emergency action in the Court of Common Pleas by way of a temporary restraining order to stay that demolition.
Got it. And in terms of in any of your record review, did you see any application, either after the citing, after sending the unsafe violation, or even before that, of any attempt to apply for a Make Safe permit for this property?
In preparation for today's hearing and looking at the case record, there has never been a permit application associated with a structural repair of this property.
Okay. Of any kind, is that fair to say?
Correct. Okay.
And there was also some indication that, city contractors have different requirements than, any other contractor that hasn't approved by the city. Is that true?
So the master demolition program basically allows the demolition to proceed under that program, but the demolition contractors are still, they still must follow a site safety plan. In this case, this property must be taken down by hand, starting with the roof line and proceeding as it is adjoining to attached structures. So it must be taken down by hand, and it must follow the entire master demolition program that's governed by the procurement department.
Okay. And, in your experience, when a building also needs to be taken down by hand, as opposed to, bringing in machinery to do the job, that also increases the cost of that demolition. Is that correct?
Correct.
Okay. And just, I think this is pretty clear from the photographs, but if you could explain to the board the kind of danger this building presented, on November 1st as it was actively collapsing.
The property was declared as eminently dangerous, and it followed the terms of specifically just that. It was an imminent danger to the adjoining properties, to any occupant or any passerby. It was also a danger to any occupant or happened to be going into that property at that time.
Okay. I don't have anything further. I would just ask for all of the city's exhibits to be incorporated and admitted.
Do Any board members have questions of what's just been presented?
Nope, that was a very well done case in chief. Thank you.
And your exhibits are all admitted into the record.
Thank you. Oh, and I didn't forget.
Did you have anything else to add?
I believe
Just to enter the square footage that.
yes.
I'm
It
okay
looks
with that.
yes on the OPA website. It does seem. I'll just share my screen. I think that's easier. There we go. So looking at the OPA website, it does look like the lot size is 1435. Total improvement area 2573.
Thank you.
Yep.
Oh, okay, that's right. That was the question that was outstanding earlier. Thank you for the reminder and getting back to that for us. Okay. Is the board ready to step aside and consider a decision?
I'm sorry, can I ask the inspector some questions?
Right, my apologies. Just as you started to speak, I realized that I had skipped one other important piece. Did you have anything to add before we step aside?
Yes, I just had a few questions for the inspector.
Go ahead.
During COVID, was LNI accepting walk-in visits?
Walk-in visits, yes. We were actually, for unsafe and eminently dangerous properties, we were asking for submittals to be done, and we still ask for make safe or structural repairs to unsafe and eminently dangerous properties to be made via an appointment, which means you go to LNI's website, you schedule for an appointment, the appointment is made, and you come in at the appointment time. For this case, and for around this time when COVID was going on, the process was that a submittal was to be done at our North Central office, which is the office on Cecil B. Moore. But you can still schedule, you could still schedule a inspection on LNI's website or a appointment on LNI's website.
Okay, but that was a little bit different than pre-COVID, where anybody could freely walk into the MSB building and visit the LNI headquarters, correct?
Pre-COVID, yes, you could walk into the department and you could submit an application in the concourse. You did not have to make an appointment.
Okay, and does LNI accept partial completed applications?
Well, if it's partial, then it's not completed.
So you all don't accept it?
If it's partial, it's not completed, so we would reject it.
Okay, and what's needed for a make safe permit?
I'm sorry?
What are the documents that are needed for a make safe permit?
You need to have a engineer's report depending upon the details of the means and method of repair from that design professional. Plans may be required, but that's up to the examiner who is detailing that specific means and method of repair. And then once that is reviewed, the contractor who's associated with the repair has to go through a form check in that their insurances and documentation has to meet approval by the department, and then a permit would be issued.
Okay. And what are the documents needed for a contractor that would win an emergency curbside bid?
What's that?
A city approved contractor that wins an emergency curbside bid for demolition have an engineer report?
Your audio broke out.
So Pedro Palmer in this instance, who was the winner of the curbside bid, were they required to have an engineer report?
They're required to have a site safety plan filed with the procurement office for any demolition that is being done in the city. In this case, it followed the master demolition program, which means that this property is brought down by hand, starting with the roof line and continuing until they reach grade level. They have to keep all their documentation current and up to date with the procurement office.
I do just want to lodge an objection to this line of questioning. What it sounds like the petitioner is trying to get at is that he does not like the master demolition plan and its requirements. That's really not before the board and doesn't have anything to do with whether he, whether this bill is accurate. So I would just lodge my objection to these questions.
It's noted.
Yeah, just to where I'm going, as I stated in my previous testimony, that there's a difference between all the steps that a private citizen has to go through versus somebody that's on the city approved demolition list.
Yeah.
And then also,
again, just objecting.
Then also where I'm saying,
Noted.
if I have, if I had a contract.
And Mr. Anderson, we did hear this from you before. We do understand your
Right.
objection to these processes.
We were letting you continue in case there was something new and different, but it does really rehash a lot of what we heard before. Are there any other closing comments from the petitioner and or the city?
Yes, I mean, so just for me, just to kind of rehash like where I was going, I won't take a lot of time. Just the difference between a site safety plan is not the same as an engineer's report. The site safety plan is not the same as a bracing plan. These are things that are required. And then also the one question I didn't get to ask the inspector is, to resolve the findings of the second and third floor collapsing, would removing the second and third floor resolve the violation?
That's past tense at this point and might be interesting to pursue, but probably doesn't really affect our decision at this point in time.
Yeah, I guess I'm just trying to show that I could have made the property safe if given, I mean, even if.
Right, but the timing was such that you couldn't have done that under the circumstances that existed at that particular point in time based on the testimony that's been given by you and by others.
So that's if I could have followed the plan, so I had a city approved demolition contractor, if they could have followed the master plan and remove
but that didn't happen, and so I don't think there's anything that we can deal with at this juncture on that.
It didn't happen because there's a difference in between a private citizen versus this approved person. If I had that approved person, so I'm saying, the property
that didn't happen, and so we're really not faced with that as a reality that we can deal with today.
But we do understand your objection to some of the processes that occurred.
Right. Any other comments that we need that haven't already been raised, either by the city and its witnesses or a question from any of the board members?
I'm ready to go back.
Okay, the board is going to step aside to consider a decision.
Everyone can just hold tight. Thank you. What just happened?
We're still watching.
I don't know, you disappeared and the rest of us stayed.
Yeah, I'm like, why am I here?
There we go.
Okay.
Sorry.
Hi, Jordan. This is the court reporter. Can I get the spelling of your last name?
Sure. Anderson.
Okay, thank you. I wasn't sure I heard it correctly.
Nancy, everyone is back.
Okay, fine, thank you. The board's reached a decision. It's our decision that the petitioner did not meet his burden, and we feel that the city acted reasonably in light of the building beginning to collapse and all of the other pressures there in terms of the buildings that were close by. And as a result, we deny the petition. Do I have concurrence from board members or any additions that I have left out of that statement?
Paula Weiss, I concur.
Dominique Ward, I concur.
George Matthews, I concur.
And Nancy Cameradiner, I concur. You'll get a letter from us that spells out our decision. Both sides do have the right to appeal to the Court of Common Pleas within 30 days of the date of our letter. But I'm going to assume for the moment that neither side is going to choose to appeal. And we would ask that if you have any questions or need to deal with anything with the city, that you work on that and enter into payment arrangements. We thank you very much for coming and joining us and for going through all of this process with us. It's been a time-consuming but very informative effort.
Thank you, board. That does conclude my
Wait, we need concurrence from all board members?
We did concur.
You did.
Okay,
Yeah.
sorry.
Yeah,
Okay.
we got that in this time without a prompt. Is there anything else that needs to, we do have something else that needs to come before the board. And we have two other items that are on our agenda for.
Can we excuse the petitioner now?
Yes. Mr. Anderson?
I'm sorry, what's that?
Mr. Anderson, you can leave now if you want.
Okay, thank you. I'm sorry. I thought you realized that. Items 3 and 4 on our agenda for DR Builders 35 LLC property address at 611 Emily Street. Do we have anyone here from the petitioner?
No, it is approximately 4:10 and there is no petitioner here in 100 South Broad Street or in the virtual hearing room waiting room.
Does the city have any information about this matter?
Well, at this point, we would be requesting that the appeals be denied for failure to appear.
Has this been up before in any way, or is this our first time to have it?
This has been listed once before. At that time, the board actually continued it. There was no quorum. This was a day where it was just Nancy and Paula here.
Okay, so from that standpoint, then it's as though this were the first time coming up for consideration. So we would be denying this for failure to appear. Does the board concur?
Paula Weiss, I concur.
George Matthews, I concur.
And we had Paula here. She left a note, but she had to head out, but she was concurring. And Nancy Cameron. I'm sorry.
Paula's still here. Dominique had to.
I'm sorry. I thought I said Dominique. My apologies. I was actually looking to see if that note was still on the screen, and I guess I saw your face and that note from Dominique. My apologies. So this is being identified as denied for failure to appear, and that is the last thing we have on our agenda. Anything to add from any other parties before we adjourn?
Thank you, everyone, for your patience today.
Bye, everybody.
Have a good one.
Bye now. Thank you all.
Bye.
Bye-bye.